expressive playing field.
And just to clarify, if you listen to what Dan's position is and my position, he's really stressing the freedom of speech side, and I'm stressing the freedom of association side, and the way that Justice Ginsburg handled it is she said that they were so intertwined that they were inseparable. And I think Dan probably agrees with that position, and I don't. So that, I mean, that's a statement of, that's not an argumentative statement. I think that's...
Yeah, I partly agree, but actually this is one aspect of the majority's opinion that did bother me a little bit. I mean, I agree, I do think that the viewpoint discrimination issue is different from the kind of issue that was presented, for example, in the Boy Scouts versus Dale case, right? Where the state is saying, not just you don't get state support or official recognition if you discriminate, but then you can't discriminate, period. Right? That's when I think the freedom of association issues come into play. Yes. So one last question.
Oh, okay. So I think at the heart of all the questions, the student questions, like concerns, go toward the conscious or subconscious sinister motivations that might exist. Now, Professor Tokaji, you have always been...
On the university's part.
On the university's part. And you've always been a champion of the Federalist Society, and we're grateful, and you've added to the intellectual vigor of our debates. But Professor Goldberger, you said that you became the co-chair of the Federalist Society and the Christian Legal Society because you felt that they were under fire.
And,
so,
and there were particular times in their history.
Right, and so
I don't believe that. I believe the CLS remains under fire because of this controversy. I do not, so far as I know, believe. I don't have any reason to believe that the Federalist Society is under fire.
I don't think. Right. I don't think we are, but I just want to, maybe you can flesh out the possible, how does a school, you talked about takeover, how does a school then, in the wake of the decision, cope with these possible sinister motivations that might exist consciously or subconsciously?
Well, I think that...
I can answer that question in a minute. I think that we don't have the time for it. It's one of the lecture I used to give about the O'Brien case, the draft card burning case. If the government has legitimate motivations paired with illegitimate motivations, in a case where the court is asking whether this is a reasonable thing to do, the court will say, we'll defer to the reasonable motivations. So what it does is simply ignores the illegitimate motivation. That's a matter of law.
So, I mean, as you all probably, at least those of you who are 2Ls and 3Ls know from your common place, it's generally really difficult to show intentional discrimination, at least in the race context. And I don't think that CLS came close to meeting that burden here. Now, what I hear implicit in your question is something of a critique of this doctrine, which in the race context comes out of Washington versus Davis. And I think there's something to this critique that the court pretends that intent is this simple black and white test. But, as Professor Goldberger points out, in the real world there are lots of shades of gray when it comes to intent. And I think that's a fair point, and that maybe we should undertake a comprehensive revision of what we mean by intentional discrimination, not just in the religious context, but in the context of race discrimination.
Now you see it's radicalism, because the court is absolutely...
Yeah, absolutely.
I share his view, but I don't think the court will ever do it.
So, and this is partly why I think, as a matter of existing law, this isn't too hard a case, notwithstanding what Professor Goldberger says, because they didn't come near meeting this high bar that the court has set in other contexts for intentional discrimination. I think, your suggestion that the court should revisit this line, maybe that's not what you mean, but the line is not as clear as the court sometimes pretends. Okay, I think there's a lot to that. All right. Well, thank you all for coming.